All right, hi everyone. I'm happy to be speaking to you today about a project that we've been working on for a number of years. We have been trying to compile a database or an ongoing record of exonerees in a Canadian perspective. And for today's purposes, I'm going to be looking specifically at the role that DNA testing played in leading to the Innocence Revolution. Historically, when we talked about things like wrongful convictions, they were considered a theoretical possibility, but essentially a non-existent thing. Going back to the famous maxim of Lord Blackstone in the 1700s, the saying that it's better that 10 guilty men go free than an innocent person go to jail. It was conceptualized as a possibility, a theoretical issue, but nobody really thought that they happened. They were more often referred to as a specter or a ghost or an impossibility. So the early discussion basically said these things don't happen, right? It's our justice system has checks and balances. It doesn't happen. The earliest attempt we've been able to find to see if these things are actually occurring went back to 1912, where the American Prison Congress Review conducted a survey of American prison wardens and just asked them flat out, have you ever executed an innocent person? Which came back with a resounding no, we have never executed an innocent person. And so they concluded these things don't happen. Clearly methodologically flawed, problematic, but at least it was an early attempt to address the question. There are other times over the 1920s, 30s, where the case law would sort of grapple with the issue, but they would refer to it as a specter or an illusion or an impossibility. Still, that's how the courts were treating it. In the 1930s and 1960s, we saw a number of sort of dramatic cases that arose just serendipitously where somebody had been sentenced to death for a murder, and it turned out that murder victim was actually on vacation and showed up just hours before the execution. These dramatic cases. Or we find out that indeed there was no murder, it was fabricated by a victim, or that the true culprit was eventually identified. Despite some of these cases emerging, the criminal justice system really still treated these as a very rare phenomenon or a fluke, really. And that's the way it continued on for the next 50 years or so, until we got the emergence of technology that could actually be used to corroborate somebody's claim of innocence. This is a picture of Gary Datsun. He's the first man to have been exonerated through the use of DNA evidence. Gary Datsun is kind of a good example, a good test case, if you will. He, in the late 1970s, was accused of kidnapping and raping Christine Cromwell Webb. She later, a number of years later, came forward and said that she had fabricated the entire story. She was a 17-year-old girl. She was sexually active, was concerned she might be pregnant, so she concocted this story so that she wouldn't get in trouble with her parents, picked him out of a photo lineup. He ended up getting sentenced to prison for 25 to 50 years. She later, in a crisis of conscience, found religion, came forward and said, no, I want to recant that. It didn't even happen. There was no crime. Trial judge refused to accept her recantation. It wasn't until his lawyer said, hey, there's this thing called DNA testing, let's get that done, confirmed the DNA taken from the crime scene matched her boyfriend and not Gary Datsun. So finally, 12 years later, he's finally got his name cleared and is given his freedom. Proof, not only did they not have the wrong person, but the crime itself hadn't even occurred. And had it not been for DNA, his name would still be associated with a horrific crime. He was the proverbial pebble that started the avalanche of the innocence movement. So a number of people came forward saying, I have been protesting my innocence all along too. DNA testing started confirming a number of these people who are claiming innocence actually indeed were cleared. Their names were clear. They were innocent, as they had said all along. Many of these exonerations were from the death sentence or for life in prison. And I think there were some cases where people had actually been executed for a crime where they were later found to have not committed. The importance of this is that it was a foundational change to the way we approach justice and law. This was no longer a specter or an illusion or a ghost. It was a reality. We were finding case after case after case of people who were completely innocent, had years or even decades robbed from their lives by the criminal justice system, which was supposed to be infallible. Now we're seeing fallibility, right? That, of course, led to ongoing research trying to estimate, well, geez, how often has this been occurring, right? There's a number of estimates. I'm just putting up a couple of the more commonly cited ones. Reisinger in 2007 had a look at cases between 1982 and 89, cases where we have maybe some evidence that we could use for testing, and found that between 3 to 5% of capital rape and murder cases involved an innocent person. That's quite a high estimate, actually. Samuel Gross and colleagues provided an estimate for a time period going forward, 1989 up to 2003. Their estimates put it at about 2% of the death penalty cases imposed in the US. A recent one that just came out in December, Samuel Gross, also involved in this study, a decade-long project, looked at available rape kits in Virginia. Many of you may know there are thousands of rape kits that are untested in the United States. The DNA gets collected and sits on a shelf. Well, a number of cases in Virginia came forward where they found the DNA could have cleared this person's name. Somebody was sent to prison when there was available DNA that wasn't tested. So the governor of Virginia ordered all of these kits get tested. And so Samuel Gross got involved with that project. Of course, very expensive and very long term. It began probably about 10, 15 years ago. That research, preliminary reports are out now. Between 1973 and 1987, they had a few hundred viable DNA kits left. I mean, going back to the 70s, DNA may not survive forever. But of the viable kits that they tested, they found just about a 12% error rate. So 12% of the people who were sentenced to prison were actually not matched to the DNA from the crime scene. Doesn't mean necessarily they're 100% innocent. We don't know exactly how that plays out in terms of the forensics of did they go to jail, were they exonerated, were they involved some other way. But that's an alarmingly high estimate, right? So cause for concern. And as of this morning, the National Registry of Exonerations, run by the Innocence Project and the Michigan Law School, they have an ongoing database looking at wrongful convictions in the United States. They have recorded just about, I think it's 2,161 exonerations in the United States, of which 420 involved a DNA-based exoneration. So that puts it at just about 20% of our exonerations involved DNA. That brings me to the present research. So we know quite a bit about American data. The National Registry of Exonerations, for example, is an American project. But we're looking to add the Canadian voice to that because we do have a unique history, a different legal system, a cultural context. There's a lot of factors that are involved in Canada that may or may not apply in an American context. So we'd like to actually keep track of what we're doing as well in Canada. So this has been an ongoing effort. Reviews of Innocence Canada, formerly known as the Association in Defense of the Wrongfully Convicted. They've represented 21 people. Their logo here actually reminiscent of counting off days in a prison wall. Each stroke there matches an exoneree that they've helped to represent and get out of prison. So we reviewed their records. We also reviewed commissions and inquiries where a known wrongful conviction has occurred. We sort of looked through those and coded all the information there. And other publicly available information, so news articles or academic reports by scholars, that sort of work. Compiled it all together, and then we've been tracking that. What I'm going to focus on today, other than just a bit of an overview of what picture we're seeing, is how DNA played a role in the Canadian context. So, just as a surface level overview, we identified 69 exonerees in Canada. We're not claiming that to be exhaustive. Certainly there will probably be more out there, but these are the ones that we've been able to very firmly identify, and it's a good ballpark estimate, we think. Of the 69 exonerees, 61 of them were men. Okay, so primarily we're looking at exonerations for men. Majority of them received a custodial sentence, and of those, more than half were for life. Okay, so we're talking about serious sentences. 2/3 involved homicide. About a quarter involved sexual assault or rape, depending on the terminology at the time of the sentencing. And then 11% we've called other, but it involves kidnapping, robbery, a combination of different offenses. The average age of our exonerees when they were convicted was 29 years. And tragically, at exoneration was 43 years. So that's a long chunk of a person's life. The average sentence was 15 years, and the average prison time was just over 7.5 years. Okay? The average time to get exoneration being just between 12 and 13 years. So it's a long-term process to get exonerated, which may be why they tend to be from more serious offenses. It just takes that long to get there. In terms of contributory factors, so these are elements in a case that have contributed to the wrongful conviction, either as identified by the legal team, the judge, the inquiry, the commission. A number of common factors were identified in these cases. Some of these will overlap. There's obviously going to be more than one cause involved in any one case. But what we see, in just over half, we've got professional or prosecutorial misconduct, so police, prosecutors suppressing evidence, coaching witnesses, suppressing exculpatory evidence, not following up on alibis, that sort of thing, right? Perjury, in 36% of the cases, this is where somebody brings a false claim. Crime never happened, I made it up, or I lied on the stand, or something to that effect. Eyewitness errors in 32% of the case. So this is a mistaken identification by a witness, or just false testimony provided for whatever reason. Faulty forensic evidence is 29%. That's a little higher than you see in the US and largely attributable to the work of Dr. Charles Smith. Many of you, I'm sure, are familiar, but he's the pediatric forensic specialist for Ontario for decades, who lacked any forensic training and who was involved in railroading a number of people for wrongful child deaths. And then finally, we see confessions and pleas at about 23% of the cases. This is where the exonerated person had given a false confession, whether coerced or otherwise, entered a guilty plea as a strategic way to deal with their case, particularly with Charles Smith, or just gave some false admission of guilt. It's quite a high percentage of the cases. So how did DNA play a role in these cases? Well, 15 of our cases involved DNA. Okay, so of the 69 cases we identified, 15 of them involved a DNA-based exoneration. 100% of those were male, not surprisingly. When you break it down by offense type, we see DNA was implicated in 21% of our murder exonerations, 35% of the sexual assault exonerations, and it wasn't involved at all in the other offenses. So we're looking primarily at the more serious offenses, where you're more likely to actually have DNA present, right, due to the nature of the offense. But importantly, it was also implicated in a number of very high-profile and notorious cases. For example, David Milgaard or Guy Palmerin, who had staunchly defended their innocence and sought every legal remedy available, got a lot of public attention over the years, and turns out he was right the whole time. That got the attention of the public and the criminal justice system and led to the development of commissions and research and inquiries to say what possibly went wrong, right? How did we sentence somebody to 2 decades in jail for something they didn't even do? Why did we deny every claim of innocence? We were wrong the whole time, right? Sort of shaking the foundations of the criminal justice system and our assumptions of infallibility. And what's interesting here is that if DNA was present, okay, I'm excluding the Charles Smith cases here, and I'll explain that in a minute, but leaving the Charles Smith cases aside because they were a weird, special, anomalous thing, if DNA is present in the exoneration, you're more likely to get compensation than if DNA is absent. You're also more likely to get an apology from the government if DNA was present than if it wasn't. And these differences are significant. So it seems that the presence of the DNA is one of these, treated as an incontrovertible fact that, you know, we're really sorry. Like, you're definitely innocent, we owe you all the money, and we're sorry with all the apologies. And for a lot of people, I mean, the money is important and well-deserved, but sometimes the apology matters more than anything else. It's to say, you have to admit what you did is wrong. I told you for 20 years I was innocent, and you told me I was a liar. So for many people, the apology itself was as important as any sort of, you can't pay money to somebody for their life, right? Money will never give you back your years, but at least an apology is a start. Just in terms of overview and general conclusions, unsurprisingly, DNA did play a role both in the American and Canadian justice system in terms of proving the possibility of wrongful convictions as a reality. It's particularly important in terms of sexual assault, mostly because that's where you have DNA available to test. DNA, where it is present, increases the chance that you'll get compensation and apology. It seems to be a profound source of evidence in terms of proving your innocence. The association of DNA to some of these high-profile cases, I think, is what really led to the Innocence Revolution, where we see these cases have been in the news, like the Tragically Hip are writing songs about this guy, right? He's in the news every night. He was right, he was innocent. That made us look and hold up the mirror back to our system and what are we doing? But importantly, it also is one of the first ways that you actually had a way to clear your name. If people couldn't say you got a legal loophole, that you fell through the cracks or you tricked the system, you were actually innocent. So that is one of the, I think, the profound implications of DNA testing.